Breaking news, guys. Wahala don shele for High Court as Kanu rejects Justice Nyako's ruling on charges against him. Now files appeal against Nigerian government. Kanu, who filed the appeal through his lead team led by its elite counsel Nyako, rejected the March 19 ruling of Justice Nyako on the criminal charges the Nigerian government preferred against him. Hey guys, welcome back to Prospect Channels TV. Thank you for always coming out here. If you're just joining us, please kindly subscribe and don't forget to give us a thumbs up. The detained leader of the indigenous people of Biafra, Nnamdi Kanu, has filed an appeal at the appeal court against the Nigerian government on the ruling of Justice Binta Nyako of the Federal High Court sitting in Abuja. Kanu, who filed the appeal through his lead team led by its lead counsel Nyako, rejected the March 19 ruling of Justice Nyako on the criminal charges the Nigerian government preferred against him. According to the notice of appeal court document obtained by Sahara reporters, Kanu's legal team informed the appeal court that the lower court held when it denied the IPOB leader his constitutional right to fair trial. Kanu also noted that the Department of State Service (DSS) failed to provide adequate facilities to prepare for the defense of the criminal allegations against the applicant and his right to counsel of his own choice, thereby occasioning a grave miscarriage of justice. The notice of appeal, which charge number FHC/ABJ/CR/3883/2015 reads: Take notice that the applicant being dissatisfied with the ruling of the Federal High Court, Abuja Division, BFM Nyako J, delivered on the 19th March 2024, doth thereby appeal to the Court of Appeal, Abuja, upon the grounds set out in paragraph 3 below, and will, at the hearing of the appeal, seek relief as set out in paragraph 4, therefore, from the Court of Appeal. The learned trial court held in law when the court assumed jurisdiction to proceed with the hearing of the criminal trial against the applicant when the applicant is glaringly denied the constitutional right to fair trial with particular reference to denial of adequate facilities to prepare for the defense of the criminal allegations against the applicant and his right to against the applicant, and his right to counsel of his own choice, thereby occasioning a grave miscarriage of justice. Fair hearing / trial bears the constitutional safeguard of ensuring that the applicant is accorded the adequate facilities to prepare for the defense of the criminal allegations levied against the applicant. The denial of the applicant the opportunity to interact and brief his counsel on what line of defenses the applicant tends to agate in the trial court and rely on was adequately brought to the attention of the trial court by motion. The trial court failed and neglected to make necessary orders that would protect the applicant's aforementioned or aforesaid right, but rather held that the court cannot dictate how the respondent carries out its work. The trial court has the powers to order the respondent, being the detaining authority, to cease and desist from interfering with applicant's constitutional/fair hearing, the right to adequate facilities to prepare defense, and his right to counsel all of his choice, and where it is impossible to do so or where the respondent persists, the trial court has the power to order an alternative custodial arrangement or non-custodial arrangement for the applicant, denial of the applicant's right to adequate facilities to prepare defense as enshrined in Section 36(c)(b) in brackets of the Constitution of the Federal Republic of Nigeria 1999 is a jurisdictional issue, in the absence of which the trial courts cannot assume or proceed with the jurisdiction over the case unless and until such facilities are accorded to the applicant. The legal team also accused the trial judge of erring when she held that I cannot make orders directing a security agency on how to do their work. I can only direct that whatever is within the law must be allowed to the defendant. The counsel cannot direct the court or give condition to the court or how to conduct its business. The defendant is entitled to a counsel of his choice and should be given the facility to conduct an interview with his counsel within the confines of the law. The detained IPOB leader, by a notice of preliminary objection prayed the appellate court to find and hold that trial in the case cannot proceed except the respondent stopped the unconstitutional act of forcibly seizing and photocopying confidential legal documents brought to the applicant by the applicant's lawyers, meant for the applicant defense of the charges against the applicant. Stop the overdropping on the applicant's confidential constitution or stop eavesdropping on the applicant's confidential constitutional conversations with the applicant's counsel, which discussion is aimed at preparing the applicant for his defense. So guys, what's your take on this? Let's hear from you. Kindly drop your comments below the comment section, and don't forget to give us a thumbs up. Thank you.